Officer Day, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. All right, let's start with Stinger and Stinger. Who are you here for, sir?
There's LV, the two, I think there's the two LVNV versus Pennington.
Okay, you're Daryl Pennington, sir?
Yes, sir.
Okay, I see we have a pair here, so let's get you two started. And you other folks, you can go off to my waiting room, Ms. Dolman and Ms. Grant. Okay. Ms. Dolman, she goes to the waiting room. All right. We are on the record. We are calling case number 2016004, LVNV funding versus Daryl Pennington. This appears to be our first pretrial. Your respective appearances, gentlemen.
Craig Fay for plaintiff P81401.
And what is your name, sir?
My name is Daryl Pennington.
Mr. Pennington, is it your intention to represent yourself in this matter?
Yes, sir.
Sir, you have an absolute constitutional right to do that. What you do not have is to write your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the very same rules that bind that lawyer bind you. Do you understand that?
Yes, sir.
All right, where are we on this file, gentlemen?
I'm sorry?
Where are we on this file?
It doesn't look like we had a chance to talk with Mr. Pennington. I'm not sure if he's up to discussing possibly resolving the matter.
Is that something you're interested in, Mr. Pennington, or should I open your discovery?
Yes, I'm open for discussion, sir.
All right, well, let's do this. Why don't I put you guys in a chat room?
Okay.
And then I'll come back to you later on and see whether or not we've been able to resolve the file. So give me just a second to get this set up.
And Your Honor, just to let you know, I'm also on the LVNV versus Holmes also.
Got it. All right, so let's put Mr. Pennington, open all rooms. Mr. Pennington, room 1. Okay. Let's try my waiting room now. Let's see how we're doing. Ms. Doman, which file are you on? No.
Sorry, I was
Which file?
Your Honor, I'm here on dynamic medical supply. I don't know if the plaintiff will appear. We have settled it, but we just haven't submitted the dismissal order yet.
Oh, you have settled it? Well,
Yes,
why don't we just go on the record? You can put it on the record. We'll kill the file right now.
okay.
Let's call your file. This is case number 201634005. Dynamic Medical Supply versus City of Detroit. Date and time set for pretrial. Could I have your appearance?
Good morning, Your Honor. Sarah Doman, P79128 on behalf of the defendant.
And Ms. Doman, my understanding is the parties have settled the case?
That's correct, Your Honor. We've settled. We've received a release from the plaintiff, and we are working on getting them a check right now.
All right, then I'm going to accept your representation as an officer of the court that the file has been settled. I will dismiss the matter without prejudice. When you get your original paperwork ready, send it on in.
Thank you, Your Honor. Will do.
We're off the record. All right. All right. What is your name, sir? All right. Who is John Ernest?
I am.
What are you here for, sir?
I'm here for, should I pull up my case number?
Yes, sir.
One moment, please, sir. It's number 201601048. I'm sorry, 048.
Okay, that's LVNV funding versus a suit against you. I have the
Yes, sir.
attorney for LVNV funding in the chat room now. So now that I know you're here, when he comes out, we'll get your case on. So I'm going to put you in the waiting room now, okay?
Thank you, sir.
Yes, sir. Hello?
Your Honor, Scary. Did you?
Good morning, Your Honor. Desiree, call Judge David Robinson and tell him I'm having problems with Can you hear me, Judge?
I'm sorry, I can hear you. What file are you here on?
Okay, I'm sorry. I'm having problems with my my speakers. I'm here on Sharon Beasley, Spectra Clinical Labs, Sharon Beasley, 20
I'm not hearing you. Do this. Write down the your case number on a piece of paper and show it to the screen. Two oh one five six. I do not have that case on my docket today, Mr. Grant.
Okay.
I do not have that case on my docket. Let me give me that number again. Let me see if I can look at my docket for another day and maybe tell you when you're on. It ends in 194, correct?
Yes.
I do not have a case ending in 194 on my docket this week. Give me that case number again and I'll have somebody here look it up and see if we can figure out what's going on for you. Okay, show me your case number again. 20156. All right, let me have my clerk take a look at this and I'll get back to you, okay? So Mr. Grant goes to the waiting room. Okay, we seem to be back on the record with case number 201600004, LVNB funding versus Daryl Pennington. You guys had a chance to chat in the breakout room. Were you able to work it out?
Correct. We were able to work it out via consent judgment. Mr. Pennington agreed to make $50 payments on the complaint balance plus the cost of filing and service. And the first payment would be due April 7th and then continue on the 7th of each month.
So the amount claimed in the complaint is $1,459.14. Is that correct?
Correct.
And Mr.
And I
Pennington
believe-
agreed to pay that amount plus filing fees, service fees, and the $75 attorney fee?
Not we don't have the $75 attorney fee. It's just the service fee and the filing fee.
Okay. And you gonna make those payments in what amount?
$50 per month, beginning April 7th.
Is that your agreement, Mr. Pennington?
Yes, Your Honor.
You understand that agreement
Yes, sir.
and you agree to its terms?
Yes, sir.
All right, this is what I'm going to do. Since both of you have agreed to the terms of the settlement on the record, I'm going to treat this as a settled case. I'm going to dismiss this matter without prejudice. What I'm looking for, counsel, is my original consent judgment and send that in and we'll get it entered. In the
Sure.
meantime, I have your other opponent for you,
Okay.
okay?
Thank
Mr.
you.
Pennington, you're all set. What'll happen is he'll send in the consent judgment after you sign it, and then I'll enter it, and then you guys will be all set.
Your Honor, would we be able to submit it under the 7-day rule, or do you want us to mail it to Mr. Pennington himself?
Well, Mr. Pennington needs to sign a consent judgment.
Okay,
Yes.
Yeah,
so we'll send that out within the next few days. It'll be mailed out.
that'll be fine. And then today I'll send out to both of you a dismissal without prejudice based on the terms of the consent judgment placed on the record. Thank you, gentlemen.
Thank you.
Thanks a lot, Your Honor. Thanks a lot.
No
Take care.
problem. You too.
Take care.
All right, you're all set. Mr. Pennington is done. I have your other case here, counsel.
Okay.
We are on the record calling case number 201600048, LVNB funding versus John Ernest Holmes. Your respective appearances, gentlemen,
Craig Fay for plaintiff, P81401.
and your name, sir.
John Ernest Holmes.
All right, this is our first pretrial in this matter. Is it your intention, Mr. Holmes, to represent yourself?
Yes, sir.
Sir, you have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that lawyer will bind you. Do you understand that?
Yes, sir.
You guys had a chance to talk about this thing?
No.
No,
All right, would that be something you guys are interested in?
I would, if Mr. Ernst is willing to discuss, then, we can go to a breakout room. That's fine.
No?
Yes, I'm willing.
Okay, well, let's do this. Let's put you guys in the breakout room to give you an opportunity to talk.
Okay.
Oh, this isn't working. Equipment rule 4. Okay, I think I've got you guys in the breakout room. You haven't gone yet anywhere, sir. Let me try.
Okay. Do I need to click on something? Oh, yeah.
I might not have done that correctly.
Okay.
Give me a chance here. I thought I had you in 4. Oh, here it is. Okay. What happened? It's not in there. All right. Now, I need to find out Mr. Grant's file. Mr. Grant.
Yes,
This case 20156-194 was dismissed on February 8th. So that's why you're not on my docket today.
yes,
Okay?
thank you.
You're free to go, sir. Sorry about that. Okay, I seem to have both sides back on 2016048, LVNV funding versus John Ernest Holmes. Your respective appearances, gentlemen,
Craig Fay for plaintiff, P81401.
and your name, sir.
John Ernest Holmes.
Were you guys able to work it out?
We were not able to resolve it, so if we can just, I guess, have a pretrial order issued.
Then
There's a
what I'll
potential, sorry.
open your written discovery.
Mhm.
And I'll give you a return date. The next pretrial date will be April 12th at 10 o'clock. Does that work for both of you?
Yes,
That
sir.
works for plaintiff, yes.
Okay, April 12th at 10 o'clock it is. Let's keep talking and see if we can't get this file resolved.
Will do.
All right, thank you.
Thank you.
Out of order to both of you, so we'll talk again on Zoom, April 12th at 10 o'clock. Thank you.
Perfect.
both for
Thank
coming.
you.
We're off the record, gentlemen.
Thank
All
you.
right, have a good day, sir.
You too. Bye.
All right, let's get started. Mr. Cohen, what do you have here?
I have Detroit Anesthesia Group versus City of Detroit.
And Ms. Bradley, you're here for that?
I'm Your Honor.
Okay, then I'm going to put you other guys into my waiting room. We'll get started on this file.
Okay.
Mr. Kovitz goes to the waiting room. Ariana goes to the waiting room. Where'd Cohen go? No. The Cohen is admitted. Sent the wrong guy to the waiting room. Now I think we got it.
Okay.
All right, this is 744. We are on the record. We are calling case number 19181-744, Detroit Anesthesia Group versus City of Detroit. This appears to be our initial pretrial. Your respective appearances.
Howard Cohen, P41346, appearing on behalf of the plaintiff, Detroit Anesthesia Group.
Good morning, Your Honor. Yvonne Bradley on behalf of the City of Detroit, P54885.
Okay, so we are at our first pretrial. Have we done our disclosures?
We are better than that, Your Honor.
I'm sorry?
We are better than that. We have
We have a
actually,
settlement, maybe.
We have a settlement.
Yeah,
That's even better.
right.
Okay, tell me about the terms of your settlement.
The terms are the city will pay to Detroit Anesthesia Group and Bayshore Green Law Firm $4,825 up to the date of March 1, 2021. It's subject to city council approval and time is not of the essence. Is that correct?
Ms. Bradley, is that your agreement?
that is correct, Your Honor.
Accepting both of your representations as an officer of the court, terms of your record haven't been placed on the record. Your settlement hasn't been placed on the record. We now have a settled case. What I will do is I will send out to both of you today a stipulated order of dismissal without prejudice. When you get your paperwork done and all the other stuff is done, send in your final paperwork, again, original paperwork, okay?
Okay, thank you.
Now, come back anytime you can settle at first pretrial.
Okay,
Thanks for coming in.
thank you.
You guys are free to go.
Okay, thank you. Have a good day.
You too.
Bye-bye.
All right, one down, 4 more to go.
Okay, I accept your apology.
All right, let's start with Mr. Crackerville. I think you were here first. Who are you here for today, sir?
I am representing Bestials Auto Sales, and the defendant is Virginia Shields.
All right, is Virginia Shields here?
Yes, I am.
Who said yes, I am?
Virginia Shields.
Okay, do you have video?
No, I'm actually at work and I'm on a landline.
Oh, well, then I guess you won't be appearing on video. Okay, all you other guys then, you stay there and we'll do this pretrial. We'll get back to you. So you stay there.
Do you want me to try to log on to video?
No, stay where you are. We'll do it next time. You're here now.
Okay. Okay.
And Stinger, you back to my. Okay. 270. We are on the record. We are calling file number 21142-270. The case is entitled Best Deals Auto Sale versus Virginia Shields. This appears to be our initial pretrial. Your respective appearances.
Good morning, Your Honor. Brent Creative appearing on behalf of plaintiff Best Deals Auto Sales, Inc., P75845.
And what is your name, ma'am?
Virginia Shields.
Is it your intention to represent yourself in this matter?
Yes.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that lawyer will bind you. Do you understand that?
Yes, sir.
Okay, where are we on this file, people?
Well, Your Honor, I actually have not had a chance to speak with Ms. Shields, and I'm not sure if Ms. Shields has filed an answer in this case or not. If she has filed an answer, my office has not received it. This is a bit of a unique case in that it was originally filed in 45th District Court, and then we changed the venue to 36th, and we had some issues with transferring it over, things getting lost in the mail because of COVID and no clerks being there in the court, Your Honor. And so I don't know if the court set this for pretrial simply because it's a change of venue or if there was an answer filed. And if there was an answer filed, I'd like an opportunity to speak with Ms. Shields. We could either do that today or if she wants to exchange, contact information, be happy to speak to her outside of court. It's a relatively low balance on this, Your Honor, and there is a troubling factor based on the location of the vehicle, which might be something that we could resolve. I guess I feel like this case is a decent chance of being resolved. So,
Yeah.
Well, I don't have an answer from Ms. Shields. The practice is when I get a case transferring venue from another court, I set the file for pretrial because I never know what's going on in that other court. But why don't I put both of you guys into a chat room and see if you can resolve your file? Does that work for both of you?
That's
Yes.
fine, Your Honor.
Okay, hang on for just a second. Let's see if I can get this right this time. I'm not doing too well with this today, I got to tell you.
Okay.
All right, let's get to a breakout room. All right, so I've got oh, I see put in different rooms. That's not going to help. Yeah, okay, that should do it. Okay, now let's see if we have a pair anywhere else. Okay, let's start with Ariana. Why are you here?
I have a court date with Dearborn Total.
Anybody here on Dearborn Total Auto? Okay, I do not have a pair for you, so you're back to my waiting room.
Okay.
Mr. Hildebrandt, why are you here?
Your Honor, I had a pretrial scheduled this morning in Advanced Surgery Center. We called and indicated to the court that the matter had been settled. You asked us to fax something. We faxed a letter to that effect. We faxed a stipulation in order for dismissal, but we didn't hear anything from the court. And so I'm just here to inform you that the case is settled and we faxed the documents to your attention.
Your fax just arrived.
Thank you.
Your fax just arrived. So what I'll do is I'll go ahead and I'll dismiss your file. When I get your original pleadings, we'll close you out.
Thank you very much, Your Honor. I
Thank you,
appreciate
sir.
your time today.
Have a good day.
You too.
Okay, he's all set. Let's close this one. Surgical Center. 615. All right, this is done. Yes, I want to remove him. Okay, and Ms. Naming, turn on your, why are you here?
Morning, Your Honor. I'm here on the Detroit anesthesia versus City of Detroit. I believe we have settled the matter.
Is that 181744?
Yes.
Yeah, they were on earlier.
Okay, great.
Place of settlement on the record. So you're good to go.
All right, wonderful. Thank you so much.
Okay,
Okay, bye-bye.
all right. And I think I don't have one for you yet, but I think I have another pair on the other one. So you're back to my waiting room.
No problem.
And admit Stinger and Stinger. No. Admit Ariana. Admit Trevor Stratton. I think that's what the case is. All right, I think I have a pair on Dearborn Total Automotive versus Ariana Fleming.
Yes.
Okay, let's call your file. We are on the record calling file number 20160526. Dearborn Total Automotive versus Ariana Fleming. This appears to be our first pretrial. Your respective appearances.
Good morning, Your Honor. Trevor Stratton, P65124 on behalf of the plaintiff.
And what is your name, ma'am?
Ariana Fleming.
Is it your intention to represent yourself in this matter?
Yes.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that lawyer will bind you. Do you understand that?
Yes.
Where are we on this file, people?
Well, Your Honor, this is one that I recently had reinstated. I think it was, I'm not sure which one it was. I think it's the one that I appeared 2 days after on the wrong date. So this is a first pretrial. I'm just looking for discovery and to set this case on track.
Okay, well, let's do this. You guys are not ready to resolve the file. Let's open your written discovery and get you a return date. Is April 8th? April 8th, does that work for both of you for your next day here?
Let me look, Your Honor. April 8th is fine with me.
How about you, ma'am?
Yes, that's fine.
Okay, April 8th, we have our next pretrial. At 11 o'clock like today. Is there anything else we could accomplish today?
Not on my end, Judge.
Anything for you, ma'am?
Yeah, why is it being rescheduled?
I'm giving you another pretrial date. I'm opening your written discovery. Discovery is a means by which you get to learn about the claims and defenses of the other side, and they get to do the same with you. That obviously takes time because when written discovery is open, you have a period of time once the written discovery is served on you to serve the response to the other side.
Okay, can you enter evidence today?
Okay.
Okay, then what I'll do, I'll put you down for our next pretrial, April 8th, 2021 at 11 o'clock, and your written discovery is now open. I'll send out an order to you both today, and thank you both for coming in.
Thank you, Judge. Have a good day.
Y'all have a good day. Counsel, I take it you're here on LVNV funding versus Latanya Wash?
Correct.
Okay, I don't have your opponent as of yet. So
I was just going to give you, sorry, just give you a heads up. We were going to, it looks like our client's recalling the account, so we were going to dismiss it anyway. So I'm not sure.
You want me to dismiss the file without prejudice?
Correct.
Okay, let's call your file and we can do that. Where is the case? 6-7. We are on the record. This is case number 2016037, LVNV funding versus Latanya Wash. By a notice dated February 1st, 2021, this matter set for pretrial today at 11 o'clock. It's currently 11:14. Your appearance.
Craig Fay for plaintiff P81401.
And counsel, my understanding is the plaintiff wishes to voluntarily dismiss this matter without prejudice.
That is correct.
All right, counsel, I'm going to accept your representation as an officer of the court. The matter will be dismissed without prejudice at your request. Thank you for coming in, sir. Have a good day.
You too. Thank you very much.
Thank you, sir.
Hello.
All right, I think we're back on the record. We are calling file number 2144270, Best Deal Auto Sales versus Virginia Shields. Your respective appearances.
Morning, Your Honor. Brent Cradiville appearing again for plaintiff Best Deals Auto Sales, Inc., P75845.
And your name, ma'am?
Virginia Shields.
All right, where are we on this file?
Well, Your Honor, so we filed this as there was a conversion count in this complaint because my client never recovered their vehicle. This is about a vehicle deficiency balance. Ms. Shields has informed me that the vehicle is essentially sitting in front of her house. Sounds like it should be something very easy for my client to recover. And because of that, and because of the fact that once they recover the vehicle, a new deficiency calculation would need to be made. What I would ask the court for is an adjournment. Now, I don't know what kind of time frame the court is comfortable with, but in order to repossess the vehicle, which should be able to happen within the next few days, make a determination as to whether or not it can be fixed and resold. Sounds like there's an engine issue, which could be a very expensive fix, or maybe not, hard to tell. Or if it needs to be scrapped, whatever that determination needs to be, and then at that point, assuming the balance goes down even further from where it is with Ms. Shields, either complaint would need to be amended, or I've talked to Ms. Shields about the possibility of just of settling the case, or it's also possible that the reselling of the vehicle would leave us without a deficiency balance, and then at that time the case would be dismissed also. So I just looking for as much time as possible, I guess, to make that happen. I was thinking 90 days, Your Honor. I don't know if the court's comfortable with that or not.
No, that's really way too long. How
Okay.
long is it going to take you to repossess the vehicle?
Only a day or two, sir, and then it's
All right, let's do this. Let's give you 30 days, and then we'll have some idea where we are at this point 30 days from now. Because by that time, the vehicle should be in your hand. You should at least be in a position to say, can it be fixed? Does it need to be scrapped? Whatever. Then we can talk about, see where we are from there.
That's fine, Your Honor.
That work for you?
It does. I
That
just
works for you, Ms.
court's
Shields?
aware that it may still be a bit of a moving target at that time. I will get my client should make that determination. The only thing I worry about, Your Honor, is if it's going to take, I don't know how long it takes to put a new motor in a car. Maybe it's less time than I think. So,
Well, first of all, you don't know that it's necessary.
Sure.
Okay. So in 30 days, we should at least be in position, number one, for your client to have physical possession. And number two, to have some idea where your client needs to go from here.
I would agree, Your Honor. That sounds fine to me.
All right, April 1st,
Okay.
I'm sorry, April 8th, that work for everybody?
Yes, sir.
Yes,
All
sir.
right, April 8th at 11 o'clock, I'm going to continue the pretrial to that date. And by that time, we should know, well, if nothing else, we'll need at least a partial dismissal of your complaint in regard to the conversion aspect of it.
That's correct, Your Honor.
So maybe we have enough information at that point to resolve everything, but at least we should be able to have the vehicle in your possession, have an understanding on where we're going from there. So April 8th at 11 o'clock, we'll try this again.
Sounds perfect, Your Honor.
I'll
Thank you.
just note on the order, vehicle to be repossessed prior to next pretrial.
Okay.
That work for everybody?
Yes, sir.
Okay,
Thank you.
then I will send out an order, April 8th at 11 o'clock. We'll be on Zoom again. Thank you both for coming in. We are off the record.
Thank you.
Thank you.